Thank you, Mr. Chief Justice. My name is Anthony Petrescu, and I will be arguing for the petitioners.
Okay, I have a few questions for you. First, does the Equal Protection Clause of the 14th Amendment prohibit race-conscious affirmative action?
Yes, the Equal Protection Clause of the 14th Amendment is a prohibition against racial classification, which is what affirmative action is. Now, there is also a caveat to this, which is also the section of citizenship. Repudiation of Dred Scott, which under Dred Scott labeled that blacks did not have certain rights. However, through the citizenship portion of the 14th Amendment, states that under citizenship or being born a citizen of the United States, that they are free from discrimination and have those rights as a U.S. citizen.
Thank you. Second, how does legislation enacted by Congress in the 1860s and 1870s affect your answer to question number 1?
We believe it does affect the answer. However, the influence of it does not have much meaning. The first thing that we go into is the Civil Rights Act of 1866, which was around the same time as the 14th Amendment, and is essentially a prohibition against race-conscious laws written by the same people that wrote the 14th Amendment, which kind of shows the meaning of the writing. The second point we had was also that the court has considered these before through Brown versus Board, where they thought that these kinds of laws were hard to resolve, and also through Loving versus Virginia, where they said that the 14th Amendment was against these racial classifications. The third portion of this was also that many of these laws are not cut and dry race-conscious laws. When looking at certain acts, for example, the Freedmen Bureau's Act, we were able to see that slaves, the argument against ex-slaves was very, very narrow. However, in case of affirmative action, it's not narrow enough in comparison to the Freedmen's Bureau Act. And the last part is also a difference between federal and state government. Congress held different standards at the time, and they thought that they were more trustworthy with their status and with their representation of the 14th Amendment, a right that shouldn't be given to states.
Thank you. Third, let's assume that the framers of the 14th Amendment concluded that race-conscious legislation was constitutional in the 1860s and 1870s. Would that argument still work more than 150 years later in a very different society?
We don't believe it would, and the first reasoning for that is the fact that this was created to remedy against the actions that had been dealt to African Americans at the time. A great disservice to them and a lot of discrimination at the time. And the second part is also that it would be really hard to create one opinion for all the congressmen. We think that at the time, congressmen would have held very different points of views, and so it's really hard to think of what they actually thought at the time, but instead I think it's a lot more important to actually look at the text of the 14th Amendment and really be able to discern the meaning of that instead of trying to predict what their opinion was at the time.
Thank you. Fourth, let's assume that the framers of the 14th Amendment thought that people of African descent deserve certain race-conscious privileges due to the unique context of slavery. Would the framers have also argued that members of other races, such as Hispanics, Asians, and Native Americans, could receive similar privileges?
No, we don't believe so, and we think this is kind of a flaw in the argument to, the friends of our other side. And we believe that we can't have those just in the sense that there's so many minorities to account for. We don't think it's feasible to be able to create those kinds of breakthrough for those barriers for those minorities. And you can cite one example, and that would be Asian Americans. Through their disservice that has happened in America's past, and also given the fact that as of recently, the acceptance rates for Asian Americans has declined significantly, we don't think that those two correlate directly together. And the third thing is it would be really hard to classify for those minorities. You can take into example Afghanis who are classified as white, a classification that doesn't seem to match. And so we don't think that that would really fit for that example.
Thank you. Fifth, what would the framers of the 14th Amendment have thought about affirmative action policies that benefit people on the basis of sexual orientation or gender identity?
So that's a really good question, but I think the answer to that is we can't really know what they thought at the time. Of course, we're living in a complete day and age where that ideology is just really hard to represent. And at the time, gender identity and sexual orientation wasn't really a topic discussed about. And it's not really something that was seen as important at the time just because nobody really knew about it. And so I think it goes back to that argument that I stated a little bit earlier. I think it's really important for us to focus on what the 14th Amendment cites in the text for it, and instead not focus on what we think the congressman would have thought. It's, again, really hard to think of a sole opinion for all the congressmen, especially in an area where there's not much knowledge at the time.
And I'm Avik Garg, and I'm also representing petitioners.
Does Brown v. Board of Education, 1954, prohibit race-conscious affirmative action? In your answer, please address Bakke and Grutter.
No, we do not think that Brown alone can be fairly read to prohibit race-conscious affirmative action. That there are lines that help us in Brown, such as when they address the history of the 14th Amendment and when they talk about education's unique status. But we think that Brown itself is best read in a narrow context of segregation of public schools, and that does not necessarily apply to affirmative action. That being said, cases around Brown, such as Loving v. Virginia and the dissent in Plessy versus Ferguson, help us a lot more and are much clearer prohibitions against racial classifications generally. On Bakke and Grutter, I think it is fair to say that if this court were to decide everything based on precedent alone, then Bakke and Grutter do control, notwithstanding Brown, Loving, or any other case. But what we'd say, and the importance of Brown in thinking about this question, is the workability sort of component to stare decisis. That if this court agrees with us that Brown v. Board and Loving v. Virginia and Plessy taken together are sort of a reason to think that racial classifications are wrong and that strict scrutiny means something very different than what it means in Bakke and Grutter, then it should use that to sort of say that Bakke and Grutter are unworkable and that those are good reasons that weigh in favor of overturning both Bakke and Grutter.
In 2003, Grutter observed that 25 years after this case, the use of racial preferences will no longer be necessary to further the interest approved today. Will there ever be a point in time in which racial preferences are no longer needed? If not, should the court allow racial preferences to go on forever?
Yes, there is such a time. We believe that time is today, or indeed in 2003, because we think that racial classifications were always wrong and they were never needed because, as Justice Thomas, citing Frederick Douglass, said, African Americans can stand on their own legs, and that is what the court should allow. That being said, this question is important because it sort of talks about what the path going forward is if we decide to stick to Grutter. Grutter sort of said that there's these diversity rationales that help universities, but those diversity rationales should go away in 25 years. Our experiences in the past 20 years has been that there is no sort of roadmap for ending affirmative action. And while our friends on the other side are can disagree with us on this, we do not think that the University of North Carolina has any plans to do so. And with that being said, we think that it's really important to sort of reconsider what Justice O'Connor said about us needing to have an end date for these sort of racial classifications, and that we do not think such an end date will ever come if we stick to the command of Grutter. Should Grutter v. Bollinger be overruled? Please address the Supreme Court's recent discussion of stare decisis in Dobbs v. Jackson's Women's Health Organization. Yes, we believe that Grutter and Bakke should both be overruled. And we think that Dobbs is pretty clear that although we need to respect past decisions of this court, that they are not an inexorable command, that we need to look at the stare decisis factors. So we group these stare decisis factors mainly into three buckets. First, the wrongness of the decision. And we think here that Grutter and Bakke are plainly wrong, that they conflict with sort of this court's decisions in Brown, Loving, and the other cases in the lines of racial classifications, and that moreover, that they offend the original meaning of the 14th Amendment, and that they are also egregiously wrong in that their logic just does not sort of stand up to scrutiny. Grutter specifically talks about how there's some sort of difference between a critical mass of racial minorities versus racial balancing itself, which it agrees is flatly unconstitutional. And we think that difference does not exist. To say that a critical mass is important and is a compelling interest because it serves other compelling interests is just sort of moving the stick like one step down the road, and we do not think that's appropriate, and that instead you should define the compelling interest as what it is that diversity actually protects, and then we can actually analyze that later on. A deferential standard just allows universities to use race far, far too much. The second bucket of this is sort of the workability concerns. I addressed this in the last question, but quite simply, Grutter and Bakke do not cohere with the other sort of decisions on racial classifications, but moreover, that these decisions just do not have a judicial standard that can be properly applied, because the judicial standard of strict scrutiny just does not sort of mean the same thing in Grutter and Bakke as it means elsewhere. And then the final bucket is reliance. And we think Grutter is actually quite unique in that the reliance interests are really, really small. And that's because Grutter itself is basically preparing for its own undoing. It talks specifically about how Grutter will no longer be like good law in 25 years, that racial classifications need to end, and that universities need to take steps towards getting rid of racial classifications. To the extent that they have not done so, sort of enshrining Grutter for all times is the exact opposite of what Grutter itself would have wanted. It is a betrayal of its ideas.
If the court declines to overrule Grutter, can the plaintiffs prevail?
I think the answer is yes, and it is a closer question because, as we have discussed before, Grutter is not really clear on what it requires, and it is true that the University of Michigan's and the University of North Carolina's policies are quite similar. We think the difference is sort of how this case has been sort of proceeded below, and specifically how plaintiffs, our side, has sort of pushed our clients have sort of pushed that there are race-neutral alternatives available to the University of North Carolina. We think that most prominent would be just socioeconomic factors instead of racial diversity. This would allow us to tailor things far more specifically to the actual sort of like socioeconomic discrimination faced, and does provide the University of North Carolina with great education nonetheless. And that the second alternative would just be like lowering the eliteness standards of these universities. That's what Justice Thomas talked about in his Grutter dissent. But we think the point is much stronger here, where we have sort of raised these issues throughout below, and that this court can sort of use this as a great time to sort of clarify both Grutter and Fisher 1, which was very clear about how these least restrictive alternative means are important to consider.
If the court overrules Grutter, will the military have difficulty recruiting a diverse armed service?
I want to be quite careful in my answer here to not sort of overstep my bounds and sort of scrutinize the military's justifications, but I would make a couple of points in saying no, the military does not need sort of affirmative action policies in order to sort of recruit a diverse military. The first thing is that these universities, which we're talking about in this case and in the previous Supreme Court cases, are elite universities. They are at the top of the top. There are hundreds, probably thousands of universities in the United States, and if the military wants to recruit from those, I don't see any reason why it should have difficulty forming their sort of diverse recruitment. The second thing here is that military can have different standards, and indeed this sort of brings the federal-state issue more clearly to light. If the military wants to do something, the federal government should be in charge, not state governments. And so if the military wants to recruit more actively at the level of sort of high schools or other levels, it should be the military's job to do that, not states and not state universities. And then I think the final point here is that you should not be too deferential to the military. And I think to do so would be a grave mistake reminiscent of Korematsu, where the court said that national security is sort of a strict scrutiny concern, is a compelling interest, but then did not really scrutinize the interest that the government put forward, and in doing so allowed a grave injustice of Japanese internment to stand. And we think that this court was correct when it repudiated Korematsu 5.5 years ago, and that today it should also not make the same mistake that Korematsu made. Thank you.